All right. Good afternoon, everybody. Thank you for joining us for the first of a series of JC Law webinars. My name is Abigail Beichler. I am the director of the domestic department here, and I'm very happy to have each of you joining us for this presentation as we start to have a really generalized discussion about what the laws in Maryland will be effective this coming Sunday, October the 1st. I do want to start with a disclosure and be very clear that the purpose of this discussion and this webinar is not to provide legal advice. That's not what we're doing here today. And at the end of this, we will be providing our contact information so that you can connect with our wonderful attorneys for a free consultation if you want to ask specific questions about how these new laws may apply to your case. We are looking to have just an overview of how things have changed and what this may mean moving forward and how the courts may be looking at this. But it's not going to be a very fact-specific discussion. And with that, we'll go ahead and get started. It is important to remember that every single case is different, and that in Maryland, divorce court is a court of equity. And that means that there's a tremendous amount of discretion that the court has in applying these statutes. So let's start with, where are we today? Hopefully you can see on your screen the current statutes in Maryland, and that it allows for two kinds of divorce, absolute and limited. As of Sunday, we will be doing away with limited divorce in the state of Maryland. But since some of you may already have cases pending, may have limited divorce cases pending, let's start with a discussion of what that means. As you can see on this screen, a limited divorce does not formally end your marriage. It is very frequently referred to informally as a legal separation, something that can be filed on more limited grounds. There are only 4 grounds for limited divorce in the state of Maryland currently: cruelty, excessively vicious conduct, separation, and desertion. That will no longer apply, but what it was used for, just so everyone has a sense of really where we were in the scheme of things for divorce, was to memorialize separations and to address things like custody, child support, alimony, and temporary use and possession while cases were pending. So that is a big change in the state of Maryland. And what we probably will see are some additional motions that will need to be filed, some additional strategy points that you'll need to come up with your attorney or in your practice, but that is no longer going to be applicable. So Maryland Family Law Statute 7102 will no longer apply after Sunday. Likewise, Maryland Family Law Statute 7103 is changing fundamentally on Sunday. An absolute divorce does formally terminate your marriage. It resolves all issues between the parties and results in a final judgment. After you have an absolute divorce, that you are able to remarry once you've got the judgment in your hand. Any of the attorneys online know that we always tell our clients to make sure we've got the piece of paper in our hand before we do anything next after we have pursued our full case. In Maryland, right this moment, as we sit here, there are 8 statutory grounds for an absolute divorce, and they are memorialized in 7103, as I said before. There are things like adultery, desertion, separation, insanity, which is a ground that we really didn't use very often leading up to this, but it applied, criminal convictions, cruelty, excessively vicious conduct, and mutual consent. There are 5 of those grounds that are going away effective Sunday, and we'll talk about that in a minute, how we are changing the scope of divorce. But right now, we have both fault-based and non-fault-based grounds, which is what most states in the US have. They have a combination. As of Sunday, Maryland will be one of 17 states in the US that is a true no-fault divorce state. The 3 grounds that the legislature left us with are all no-fault-based grounds. And I will touch on where fault falls in consideration in your divorce case now that we are moving forward with these new grounds. So let's move into, as I said, those are the grounds. This is the grounds that are bolded on the slide are the grounds that are really those fault-based grounds here. As I said, those fault-based grounds are being eliminated. We are moving into our new statute. Now, it is important to note, and many people may know, that this is not the first time Maryland considered making these changes to our laws. We have had these conversations many times before. The most recent time the legislature brought this up was in 2022, when it was raised and not passed, but effective after the first reading in January of 2023. House Bill 14 has made it all the way through and will be going into effect. So what does that mean generally? There are a lot of considerations when someone is pursuing divorce. Where you're pursuing your divorce, what county, is something that we talk about a lot when we do consultations with our clients, when we strategize with our clients. And it's important to understand that where you are does have some impact on how quickly your case may move and some specific jurisdictionally or venue specific meaning. Maryland has 23 counties and Baltimore City for a total of 24 jurisdictions. Now, if you look online, most of those jurisdictions publish their DCM. And that's important because your attorney would talk to you about how your county's DCM impacts your case time standards, impacts something where you may be placed on a different track for your divorce, all within the confines of the new statute. And so it's really important to ask those questions and to understand how the court that you are litigating in has standards set up to move forward. As the slide says here, and as the new family law statute 7103 will make very clear, these are our three grounds moving forward: mutual consent, 6-month separation, and irreconcilable differences. But let's take a look at what that really means and what the language of this statute says. So this is, as it relates to separation, a pretty big change. Those of us who are practitioners may remember that not all that long ago, the standard was 2 years for separation, and before that, even longer at 5 years. We changed to 1 year pretty recently, and now we're at 6 months. It is important to note that this is something that you'll be able to amend your pleadings based upon. After Sunday, we can work to amend the pleadings and make sure that the new statute is applicable in your case, particularly if your grounds for absolute divorce maybe weren't ripe yet. Another big change that we're looking at as it relates to separation is that in 7103B, parties are going to be deemed to be separated if they have held themselves out, and we've deemed as living separate and apart even if they reside under the same roof, or if a separation has occurred in accordance with a court order. And when you're thinking about that, what that may mean for you, separation in accordance with a court order, it has a lot of meanings, but one good example would be if there's a peace or protective order between yourself and your spouse. There isn't a clear definition under the law of what pursued separate lives means. And that's why it's so important to have fact-based and really specific discussions with your attorney about what does that mean? How can we build that case and make it applicable for me to pursue this option? And we will have a brief Q&A at the end, so I want everyone to be aware of that. There is a Q&A function at the top of your screen, and my admins are going to go through those if you have questions that pop up. If your question is really specific to you, I do encourage you, and we'll remind you at the end about our contact information so that you can speak with us about your specific case. The second ground, the newest ground in Maryland, because we have 2 of the other grounds. Nothing about House Bill 14 changed the mutual consent ground, though we will go through what that means specifically, as there are requirements to pursue a mutual consent divorce. And separation I just talked about isn't a new ground, it's just a new standard within the ground. But irreconcilable differences is new. That's new in the state of Maryland. And fortunately or unfortunately, the legislature has let the Court of Equity have a very wide array of discretion in determining what that means. We don't have a specific definition of what irreconcilable differences means. 7103A2 simply says that the court may grant an absolute divorce based on irreconcilable differences, based on reasons stated by the complainant for the permanent termination of the marriage. Now you may be asking yourself, how do I know if I have irreconcilable differences? How do I as an attorney know that I've gathered the information that my client needs to pursue irreconcilable differences? Or how do I know if I can file under that ground? We have to take some guidance from outside jurisdictions because we've not done it before here and we don't have a definition from the legislature. So good places to look at are places like California that does have a defined code. Now, again, it is important to note that the law from other states is not binding on Maryland. It may be persuasive or illustrative, but it's not binding. It doesn't hold our judges to a requirement that this be what they consider when they're looking at your case. But examples, as I said, would include substantial reasons for not continuing the marriage and which make it appear that the marriage should be dissolved. Not really much clearer for anybody, but it gives you some parameters of what that may include. In New Hampshire, it is defined as differences that have caused the irremediable breakdown of the marriage. Again, not very specific, but we can take a little bit of guidance from them as we go forward. Other examples in case law, such as from New Jersey, have been where courts have determined the following things to be irreconcilable differences. So things like serious personality conflicts, excessive conflict within the home, lack of intimacy, financial problems, political views, lack of communication, and challenges within the family. That may or may not be sufficient. And what it's going to come down to is the discretion and the equity balancing test for our judges here in the state of Maryland. We even can go back to something as simple as Black's Law Dictionary, which tells us that irreconcilable differences is a no-fault ground for the dissolution of a marriage under many state statutes. Well, that didn't really tell us what we needed to know. So then it says, see, irretrievable breakdown of marriage. The irretrievable breakdown of the marriage, according to Black's Law Dictionary, is a no-fault ground for divorce, which means a condition in which either or both spouses are unable or unwilling to cohabit as husband and wife, and there are no prospects for reconciliation. As we move forward and as you look at the new statute for absolute divorce in the state of Maryland, it's important to go past the grounds for divorce and to pay attention to 7103C and D, which talk about things like recrimination. Recrimination really means, did both spouses do the same thing? And again, remember, we're not talking about a fault-based discussion. You don't have to allege that your spouse was so horrible that they should be penalized and there should be a fault finding against them. What you're really talking about is an acceptance that we can't move forward together, and so we need to terminate and permanently end the marriage. As it relates to our mutual consent considerations, that is very frequently when we speak to clients, what is most commonly referred to as an uncontested divorce. Now, it's really important to understand that just because you file on the ground of mutual consent doesn't guarantee an uncontested divorce, as we'll talk about a little bit, and as it relates to the factors that are needed to pursue a mutual consent divorce. But it is the most likely ground for your uncontested divorce. And uncontested divorces, as we all know, are a much cheaper, much more time, financial, and emotionally efficient option to a divorce if you can pursue it. In order to pursue a mutual consent divorce, the parties must have an executed written settlement agreement that resolves alimony, custody, and child support. The agreement has to have child support guidelines attached to it if child support is addressed in the agreement, requires that neither party have filed to set aside the agreement, which is the factor that most commonly can take this mutual consent divorce out of the uncontested divorce realm. And 4, that after reviewing the agreement, the court determines that it is in the best interest of any minor child or children who is subject of the agreement. That would lead us to our conversation about MSAs. Now, MSAs, or marital settlement agreements, are contracts between yourself and your spouse. They are sometimes referred to as many different things. And I will note here they are different than prenups, although that can certainly be a factor in considering whether or not you meet the grounds for a mutual consent divorce. They are different than antenuptial agreements and postnuptial agreements. Marital settlement agreements are agreements drafted and executed in contemplation of the dissolution of the marriage. They do not divorce you. That's a really important distinction. You are not divorced just because you have an MSA executed between yourself and your spouse. These documents, if you work with one of our attorneys, typically range, just depending on the complexity and the nature of the issues that need to be addressed in your specific case, from 10 pages all the way up to 30 pages. Particularly if you have children, you're really looking to be as specific and intentional as possible with any element of consideration that needs to be resolved in your MSA. We'll back up a little bit. Those are, I said I would speak about how the fault-based element of the grounds for divorce is still carried through in some of the other considerations. You may be sitting and asking, well, why did the legislature do away with the fault consideration entirely? And what do I do if my spouse or if the opposing party is acting in a manner that is inconsistent with continuing the marriage, with creating a productive co-parenting relationship, etc.? There is still fault consideration as it relates to at least a few things in your divorce case. One would be that the reason, the cause for the breakdown of the marriage, each party's role in that, each party's respective health and their contributions are explicitly enumerated in Maryland Family Law Statute 8205, which discusses the determination of monetary award. There are 10 enumerated factors and the 11th catch-all factor that spell out really specifically exactly what needs to be considered by the court in exercising its equity powers and in making a monetary award. This is also part, the breakdown of the marriage, efforts to reconcile what each party has contributed, etc., are specifically enumerated factors of the 12 factors in Maryland Family Law Statute 11106 that deals with awarding alimony. So those things really are still very much at play, something that you need to be speaking with your attorney about, and that will be ultimately part of your divorce case in just a different way than they would have been at this moment moving forward. I will take a moment to note something that I found really interesting in preparing for today's webinar, which is just that even though this is a really significant change and something that practitioners and litigants alike are going to have to get used to and are going to have to consider when listing which of the grounds they are applying for under their complaint, that the legislature only allotted $18,000 across the state of Maryland for our courts to enact programs based upon this new law. And so even though there are, as I said, 23 counties in Baltimore City in the state of Maryland, There's only $18,000 to go around. And I really think it's going to lead to a lot of probably healthy discussion and debate among our court system in what we are looking at improving those grounds moving forward. Other important things to consider. So even though the grounds are being changed really drastically, what previously was considered a ground for divorce, so those things like cruelty and excessively vicious conduct, probably will be able to be used to satisfy the irreconcilable differences ground. So if you think about what it means to really have irreconcilable differences, then those instances of cruelty probably would be sufficient to meet that ground. Can I guarantee that? Of course not. And as I said, it really is going to be tremendously up to the discretion of the trial court, as we saw in some of the other states and jurisdictions that already had this ground prior to us. And then the other part of the statute that I touched on but didn't really go through in depth is our res judicata, which says as part of 7103 that even if the court denies your divorce on one of the other grounds, which was a little bit more expansive before and moving forward will be narrower. But let's say, for example, you file under the grounds of irreconcilable differences, and for some reason, the court denies your complaint for absolute divorce and says, I don't think that this is a case of irreconcilable differences. I don't think you have met that burden, that you would still be, under the statute, explicitly entitled to pursue your divorce on the ground of separation. The court is leaving room for that consideration. I went through pretty quickly. I would point everyone to Maryland Family Law Statute 7104 that also speaks to things like reconciliation, that's not an absolute bar or defense to a ground for divorce, but something that should be considered. What's really going to be important moving forward is to make sure that you are giving your attorney, you are having these discussions about all of the important information. Anything that could be relevant should be shared. You know, it's better for your attorney to have the information and for us to know the specifics of your case and be able to guide you than for something to be hidden or left out and us not be able to really intentionally navigate that with you. So I will give a moment to see if there are any questions. Great. It doesn't look like there are questions, but what I will leave you with is that if you do have questions, if you want to talk more about this, if you have really specific questions as it relates to how this impacts your case, if your case is already moving and can you apply for an amendment based on these grounds, if you are considering starting a divorce case and moving forward, if you are an attorney contemplating how you will be attacking and strategizing on these grounds moving forward for your clients, please don't hesitate to reach out to our office, particularly if you are a litigant, for a free consultation. And certainly I welcome any discussion with the fellow members of the bar to bounce ideas off of as we navigate this really new area of the law. Oh, I'm sorry, there is one question. All right, so this is a really great question. Will any pending cases simply not have limited divorce as an option? And the answer is likely no. The court or the legislature, excuse me, has abolished that limited divorce scheme. And so that's a conversation that's going to have to be had with your attorney if what you were looking to do wasn't pursue a full-fledged divorce, but to pursue that legal separation or to address things like custody, child support, etc. on that short-term basis that we talked about. You're going to have to reevaluate what your strategy is in the case. There are really important elements of that I want everyone to understand, that in each case, there is something called a scheduling order that's issued. That controls what happens in the case and what the timelines are. That, along with that DCM that we talked about, and those are, for anyone who doesn't know, DCMs are differentiated case management plans. It's really important to know what the DCM is in your court, because it's going to have you track differently based on timings and case expectation standards. So no, limited divorces won't be granted in the state of Maryland anymore. The court has done away with them. But thank you for the question. All right, if no one has any other questions, as I said, it was my sincere pleasure, to speak with you all today and to engage in a general overview of what is coming next in the state of Maryland. And we look forward to hearing from you all. Have a good one. Thank you so much.